Division 1 is now in session.
Please be seated. We're here to hear argument in 1 CASA 170267, DOE versus Mahoney. Counsel, we have read the petition and the response. We've conferenced this case. Please keep that in mind when you make your arguments. We are recording today's proceedings, so please state your name and the party you represent before you begin. Mr. Ellman.
Good afternoon, Your Honor, and may it please the Court. Rob Ellman for John Doe. The single question for this Court's review in this case is whether it is substantially true that USAR is a scam after securities regulators in 3 different states conclude that USAR violated its anti-fraud provisions by representing that it had more gold at its disposal than all of the mines in Arizona had ever produced cumulatively in its history. And those orders describe a scam to a T. And it's the same scam that Doe writes about. It's the same scam that the state geologist writes about. It talks about the same material misrepresentations about the amount of gold, the right to mine the gold, the readiness to move forward, the ability to extract the gold, and finally, and most importantly, the profitability of this venture. If you look—
Let me just clarify something for a moment. You said that's the only question.
Can you turn on
The clock.
the clock? Look at you, Mr. Ellman. You're getting some extra time.
Oh, well, thank you.
So you said that's the only question at issue. Is it your position that under Mobilisa, the only factor we then need to consider on the summary judgment question is the defense of truth?
No, Your Honor, because all of the other more specific questions in this case are all subsumed into the single question of whether USAR is a scam. And I didn't—
Let me go through a few of those just because I want to know your position before I ask the other side. I don't see anywhere in the petition that you have suggested that the plaintiff in the underlying case is a public figure.
You're correct.
Okay. So you'd concede that the scienter requirement here is negligence?
For purposes of this case, I will concede that, Your Honor.
Okay.
Okay.
And so you're not relying then on the absence of proof of negligence to make out the position that you're advancing today?
The court below decided that it was unnecessary for USAR to present any evidence on state of mind because it was outside of USAR's control. So we're in front of you in that context. There isn't—
But are you challenging that decision by the lower court?
Well, it's an element, so of course we are, but the
But
case—
I didn't see that in your pleadings.
I'll accept the court's representation on that, Your Honor, and I'll go forward on the theory that I've already articulated, which is that it is substantially true that USAR is a scam according to the regulators, and there's also an absence of proof from USAR that would be competent to establish it even if you didn't have those agency rulings.
So you're just so I want to be clear. So you're conceding that for us in resolving this issue, that we don't need to make any finding on the scienter requirement that would be typically for a motion for defamation or a summary judgment motion on defamation.
Well, I think there hasn't been any finding on that, and it would have to be remanded for that if you felt there was anything left of the case. Yes.
Well, except I want to know, did you argue it, and do you believe that under Mobilisa that is something we have to consider?
It does have to be considered under Mobilisa. I didn't argue mental state in our petition, and I don't remember arguing to the trial court that a negligence standard did or didn't apply. I think we left open in our petition whether John Owen could be treated as a public figure. When you do review those agency findings, Your Honor, particularly paragraph 7 of the Washington Statement of Charges, which you'll see is a description of a boiler room operation. In the state of Washington, you had an unlicensed dealer calling over the telephone an unqualified buyer to sell an unregistered security based on the misrepresentations that I referred to earlier. In fact, he said that he had just come from the mine, that operations were going to begin the following week, and that if the buyer didn't act immediately, he would lose the opportunity for profits. No reasonable person would read those findings or the Arizona State Geologist report and conclude that USAR was anything but a scam. So what you have here are USAR's representations that it isn't a scam. The difficulty with that is that the agency findings are judicially noticeable. And Arizona law treats judicially noticeable findings as adjudicative facts, and contrary representations are treated as a nullity. So what you have is an agency ruling with the force of law that can't be contradicted in this case, and it is. So the evidence USAR wanted to put forward was not competent to begin with. Now, that should have ended the inquiry, but it did not. USAR escaped by saying that we're USAR, and the entity referred to in those agency orders is IER, and that's a completely different corporation, even though it was formed, owned, and controlled by the same people. But that fails for two different reasons. First, the California and Washington agency rulings both say specifically that USAR is a party that made the material misrepresentations and material omissions. So that's a non-starter because it only takes one judicially noticeable agency finding about USAR to dispose of the case. But
hold on for a second, because you're kind of getting ahead of it for a minute, for me anyway, and that is the notion that the agency findings and we'll stick with California and Washington. The agency findings in California and Washington don't support all of the statements made by Mr. Doe or posted by Mr. Doe. Would you agree with that?
No, I would not, Your Honor.
So where in the agency findings does it say that USAR bilked $30 million from the investors?
Remember, I talked about substantial truth at the beginning,
I understand,
Your Honor,
okay.
and the California order says that USAR attempted to raise $10 million and sold at least 20 interests in the venture to people in California. And then you had a reposting by Doe of another person's statement that USAR had actually bilked people out of $30 million. And when the standard is substantial truth, that distinction only matters if it affects the reputation of the person it's describing. Now here,
you don't see a distinction between attempted to raise $10 million and bilked $30 million.
the California order, Your Honor, describes misrepresentations, and the Washington order describes the boiler room. And what they establish is that they were trying to bilk people. They didn't do it successfully, but they were looking for $10 million. And they describe the way that they did it, and it's laden with fraud. They violated the anti-fraud provisions of those securities laws. But even if you could set that aside, and you were going to indulge corporate formation distinctions here, the claim would still fail for a couple of different reasons. Again, the orders from California and Washington specifically refer to USAR. But even if they didn't, all of John Owen's corporate formations are instruments used by the same people to perpetrate the same scam. This is not a corporate veil case. It's a defamation case. And the distinction between the corporate entities would only matter if conflating them altered the gist or sting of the statement, and it doesn't. And of course, that's the point that the Oaks Gallery case addresses that I gave you in supplemental authority. If this were a criminal case, I would be treating those corporate formations as an artifice to defraud. And the same artifice that sends you to prison in a criminal case shouldn't enable you to bring a defamation case in a civil matter. If you don't want to go along with Oak's Gallery or Doe's position, and you feel that corporate separateness does matter, the claim fails for two different reasons. First, the only evidence USAR has offered in this case takes the form of declarations. The declarations are either conclusory or irrelevant, and if the distinctions matter, then the declaration of Kevin Jones that the court relies on very heavily at page 5 of the ruling becomes irrelevant because it only concerns Vast Mountain and not USAR. And of course, Vast Mountain is not a party to this case. There's no other evidence of commercial activity. Forming a corporation does not go to the truth or falsity of any of Doe's statements. USAR held itself out as a large-scale commercial gold mining venture, and it wasn't. There's no evidence of commercial activity at all. Everything relates to the distinctions in corporate formation. There are 3 other errors that infected the summary judgment part of the Mobilisa test in this case. The first is that Doe did not change the meaning of that Dallas consent order in 2 ways. First, he makes 2 different messages on that message board at Investors Hub where the language is omitted. It's an ongoing conversation that continues for months. The first time he did it was on November 30th. But 28 minutes before that, another poster who calls himself Crooked Neck had published the order with the omitted language included. In fact, it was in red and highlighted. USAR doesn't discuss that. When you're part of a conversation like this on a message board, it's almost impossible for someone to look at Doe's statement and not look at USAR's. So then you move forward to December 5th, and that's the only posting by Doe that they do discuss. And again, it doesn't include that omitted language, but it was posted on the afternoon of December 5th, and on the morning of December 6th, Crooked Neck again posts that consent order, including the language of Brian Hunter not being aware of facts to support Doe's statements. A message board is a digital conversation. If I'm having a conversation and someone walks into the middle of it and misconstrues something I said because they didn't hear what I said earlier, I don't think I'm accountable for defamation. Conversations are not accumulative. You don't have to repeat what you've already said because they're already part of the same conversation. The second fatal error in the court's analysis on this point is that what that consent order from Texas actually contains is a stipulation from a man named Brian Hunter, whoever he is, and he says that he is not aware of a factual basis for the statements that Doe later reposts on Investors Hub. That does not establish the truth or falsity of those statements. But when you look at how the court characterized it in its ruling, the court said there was a finding that there was no factual basis for those statements. And that's a critical distinction. What was actually said in the order doesn't establish truth or falsity. But the court's recharacterization of it does establish falsity, and the court relied on that in finding that USAR was going to survive summary judgment in that case. The second problem, and I want to cite you to that December 6th posting. It's at Appendix 3A2, Exhibit M, Link 6. And the prior to November 5 posting is at USAR Appendix 110. That also has important implications for the Communications Decency Act argument. USAR doesn't assert that the Communications Decency Act doesn't apply. It just says there's an exception here because Doe altered the meaning of a prior statement to render it defamatory. And for the reasons I just gave you, that is not what happened. So the CDA preempts this entire lawsuit. Now, there are also 4 errors that infect the balancing test analysis. The first is the court's treatment of the type of speech factor. Now, the court said that that weighed against Doe because it exposes him to liability if the statements are false. Well, that applies to every defamation case ever, so it can't possibly be the correct standard here. Fortunately, the correct standard appears in Mobilisa itself. It's set forth in footnote 8. The Court's talking about different types of speech that enjoy different levels of First Amendment protection. This happens to be public speech on a matter of public concern, so it enjoys heightened protection under the First Amendment. The Superior Court also got the privacy expectation analysis wrong. For the same reason I just articulated, that was readopted in analyzing that. But in addition to that, the Court says that the statement Doe makes was not entitled to privacy because it was disseminated on the board, but that conflates privacy of the statement and privacy of the identity of the individual. And in the cases that we've cited, the privacy right arises from the terms of service of the Internet service provider and the website. Investors Hub would not exist if it did not allow its posters to remain anonymous, and Cox Communications offers the fullest amount of privacy it can offer without putting itself in criminal contempt, because it will protect your identity until it receives a court order compelling it to disclose. The Court got the consequence of compelled disclosure analysis wrong. I don't need to say much about that. But what the Court said is the statement, "I know where you live," is not threatening. The Court treated it as neutral. Well, if that statement is not intended as a threat, then it's a non sequitur. The people on the message board, weren't talking about their houses. They were talking about very different opinions in invective tones. And then finally, the Court got the extrajudicial remedy aspect of this wrong by simply not considering it. The cases we've cited, particularly Cahill, indicate that this is a forum where the person who claims to be defamed has instant and equal access and can easily rebut a statement if you treat the statement, as an assertion of fact. In a message board, you shouldn't do that, because that's not where people go to find facts. They go to the Wall Street Journal or Merrill Lynch or sources of that nature. When they want opinions, they go to Investors Hub. But the extrajudicial remedy here, first of all, we did argue it in the balancing test part of our motion below. It's at page
Before
18.
we get off the fact-opinion issue, opinion isn't really a relevant concept in defamation law, but statements of verifiably or objectively verifiable fact are. Wouldn't you say the statements at issue here were objectively verifiable?
Well, I would
subject to objective verification.
Well, I would say that you could treat the word scam, that seems to be the centerpiece of the case, as an assertion of fact in many contexts, but this is not one of them because of the reason people go to a message board. They expect to exchange opinions, and they're even warned.
Why people go to message boards, though?
I'm sorry, Your Honor?
How do we know why everybody goes to a message board?
Well, if you...
People get all sorts of things they treat as facts. Some of them mystify me, and I don't know where they get them. But I don't think we can say universally that people don't expect factual information on message boards. And scam sounds to me like it is susceptible to proof of objective falsity.
Well, to the extent it is, Your Honor, we have regulatory findings that establish it was a scam. So, we still should have won on the motion to quash for that ground. Again, in some contexts, I agree with you that the term scam could be treated as an objective factual assertion. But these are people debating with each other on a message board, and when you read what they've written, you'll see that this is not a place a reasonable person would go to find out facts about a corporation or a potential investment. So at this point,
it's a place where one might go to find out about a company's reputation, right? I mean, if you're concerned about reputation, you might be concerned about let's call them bad reviews, even if those bad reviews are inaccurate. The fact that people are saying bad things about you is part of your reputation, isn't it?
I think that's correct, Your Honor. I have to concede that's a fair characterization. I'd like to renew our request for attorney's fees at this time, because under those judicially noticeable agency rulings to which USAR was a party, There was no competent evidence to go forward. In fact, it would be treated as a nullity. So the case should never have been brought. And furthermore, the entire case is preempted under the Communications Decency Act. The case was not brought for any purpose other than intimidation. I think the facts make that apparent. And I'll reserve the rest of my time for rebuttal. Thank you.
All right. Thank you, Mr. Ellman. Counsel?
Good afternoon, Your Honors. May it please the Court. My name is Deborah Verdier, and I'm the attorney for the Real Party and Interests USAR. I would like to start out by addressing one primary issue that I heard in the petitioner's opening presentation to you, and that is that the only thing they're making it suggest that the only thing that DOE or Get Real published was that USAR is a scam. That disregards the numerous factual statements that were not true. And when we presented that to them as a possible defamation claim, the response was, it's the California order and the Washington order. The problem with that is it is not as if DOE published those orders and said, hey, investing world, you should take a look at these orders. It's not what he did. He mischaracterized those orders and he misstated those orders in several meaningful and relevant ways. For example, he indicated that those orders suggest that USAR is banned from selling securities in the state of California. There was not a ban. What they said was, hey, if you're going to continue to sell securities in the state of California, you need to follow the rules. You need to follow the law. They were essentially follow the law orders. And the other most important thing about that is nowhere in those orders do those agencies conclude that the security interest itself is a scam or the security interest itself is invalid. What they conclude is the manner in which the employees, not of USAR, the employees of IER, were marketing those securities violated that state's securities laws. That's different than saying this mine is a scam or the security interest that you are selling is a scam.
Well, what sort of legitimate interest can you sell that violates the state's security laws? I mean, that order surely wasn't the order that your client was looking for.
It certainly wasn't, Your Honor, but what the order states is that, hey, you are stating things about these securities that are not supported and are not, don't comply with our rules. That's different than saying, what it's saying is, if you're going to continue to market this...
It wasn't the size of the paper that the securities were printed on. The orders were based on a finding that there were untrue statements made in connection with the sales of securities, and I believe your client was admonished that if it didn't comply with laws governing truth in the sales of securities, that it would not be able to do so. Is that a fair statement?
That is a fair statement, and I think that's a very different statement than declaring as a matter of law that the security interest is worthless or that the security interest has no interest. What it's saying is, going forward, if you're going to continue to market the security interest in the state of California, you need to follow our rules and stop making misrepresentations about them.
But to that point, your client hadn't followed the rules. We're stuck with that fact.
In the state of California, there were two employees of IER, who, by the way, is not my client, Your Honor, and we did provide evidence that IER is not owned by USAR and was not owned by USAR at the time these statements were made.
Is it a completely unrelated entity?
Well, let's see. They follow all the corporate formalities. They have different owners. They file separate tax returns. They maintain separate accounting books.
But I thought the California order and the Washington order were specifically directed towards your client.
They referenced my client, but the underlying conduct that they found to have violated their state securities laws were employees of IER. And when DOE goes online and states without clarifying, hey, the DOE didn't go online and say there might be some relationship here between IER and USAR. It was IER's employees who did this, but hey, you should pay attention because USAR is part of this. DOE broadly stated and characterized and mischaracterized those orders to say USAR has been banned, which is not true, and that USAR was found to have violated the securities laws, which was not true. So it's that statement. As far as the other thing that DOE posted, which was the listing of facts from the Dallas order, the consent decree, and this relates to the argument about the Communications Decency Act, if DOE had simply published the order in its entirety, like Crooked Neck did, we wouldn't be here today. It's the other statements that DOE made. These are all true.
But is there not some privilege that attaches to commentary on government proceedings? I mean, if all anyone were able to do in discussing the results of government investigations were copy and republish the exact investigation summary, we would really stifle public debate in a way that I don't think the First Amendment contemplates, wouldn't we?
Your Honor, I don't think that the First Amendment contemplates someone going online and making defamatory mischaracterizations of those government proceedings.
Well, online may have not been contemplated by the drafters of the First Amendment, but robust and caustic commentary on the functioning of government and those who would be part of it was certainly foremost in the minds of the framers. Wouldn't you agree?
I would agree, and I would actually put it in a slightly different context. Let's say you have a former employee of a company who, for whatever reason, was familiar with some legal proceedings that had gone on with that company. And that employee is disgruntled because they've been fired. And they want to go online and they want to mischaracterize what happened in that court proceeding. Mm-hmm. And they do so in a way that is false and sheds a false light on their former employer. Then I think that would be considered defamation, even though they are purporting to characterize court proceedings.
False light doesn't apply to businesses. So let's just talk about the elements of defamation. I think if you say there was a court case and X won when in fact Y won, that would be a clear problem. But what I'm asking is whether you would acknowledge that the law recognizes a broader scope of debate concerning the import of the outcome of public proceedings than it might a simple black and white fact like X1 or Y1 a case.
I think the law does contemplate that. That's why Mobilisa put forth in the 5 factors as far as the balancing test. One of them is the type of speech. And the court below did consider that and did address that. And one of the public policy issues that was raised at the court below with respect to that particular issue is because of the Internet and the way it is, it allows for and invites mischief. So, for example, how do we know that Get Real isn't being paid by a competitor of USAR? How do we know that Get Real isn't a disgruntled former employee using the Internet?
Reporters get paid by media outlets that have sponsors that have interests. I don't think that it's ever been the case that there's been absolute purity in even the most solemn reporting. But I'm not sure that it matters what the motivation is because petitioner has effectively conceded that Scientura is not at issue in the case.
Well, not at issue in the case at this stage, Your Honor, which is why I want to
well, the only stage we're concerned with is the quashing of the subpoena.
Right. So
and I think that was the limit of the concession.
Right. So the question is are we entitled to discover Get Real's true identity?
Right.
And the court below analyzed the evidence. And the one other point I would like to make out that Mr. Ellman raised, which is the heavy reliance of the court on the Kevin Jones declaration. And I think that misstates the court below's decision. If you look at page 4 of the minute entry, which was Appendix 1 to petitioner's brief, the court cites 6 different aspects of evidence that establish the falsity of various of the statements. Of those 6, several of them, number 1, number 3, number 4, all come from the Weinsweig affidavit. Mr. Weinsweig is Mr. Ellman's partner, who's provided an affidavit in support of their petition, or I'm sorry, their motion to quash, and the court is actually using the evidence that they provided in interpreting the California desist order, for example. And so I think the other thing that's really important is that petitioners throughout these proceedings, including the proceedings below, have essentially overstated what USAR's burden is at this point. It is, according to Mobilisa, which everybody agrees controls, our burden is to show that we would likely survive summary judgment. And that means if we survive summary judgment or are likely to survive summary judgment on even one of the facts that we allege are defamatory, then we get access to the information. We get the right to conduct discovery and pursue our case. A lot of what I'm hearing from Mr. Ellman as far as USAR is a scam, and he's entitled to put that case on. The case still has to proceed, and there's still going to be a defense to these allegations. This issue is whether or not we're entitled to learn the identity so that we may pursue our claims against this person.
Okay.
Yeah. Out of these 6 statements, which one do you think survives?
The 6 statements, Your Honor, I was referencing the court's statement as to the evidence that, if true, would, and if believed by the trier of fact. I think all of the claims survive summary judgment in terms of whether or not we likely survive summary judgment. For example, the bilked out of $30 million. There's absolutely no evidence that we bilked anybody out of $30 million. In fact, the evidence is that we haven't even raised $30 million.
Would you agree that there's evidence that somebody associated with your client tried to bilk people out of some substantial amount of money?
I would not agree with that. There's
Think
no
the
evidence.
California and Washington findings support that at all?
I do not. I think that what the California and Washington findings find is that there were a couple of employees that were making overstatements and misstatements about these investments. There's no the word bilked out of $30 million implies we've received $30 million. The implication then is that if somebody wants to invest in USAR.
Hold on, before you go on. Look, whether it's 30 million or 10 million, the sting of that is that somebody was attempting to bilk large sums of money. You would agree with me?
Your Honor, he did not say attempting to bilk. He said they have bilked.
Do you want to take the distinction between bilked and attempted to bilk before a jury on a defamation case as a plaintiff? That can't be what this case is about.
Your Honor, I'm not here in front of a jury on our defamation case.
No, but
I'm here to see if I can get discovery.
I understand, but if the issue is just that the finding wasn't that they bilked, but merely that they attempted to bilk, that is starting to sound like substantial truth to me, and I want to make sure that I'm understanding the distinction you're drawing before I form an opinion, because maybe I'm misunderstanding you.
Well, to me, the distinction is this. The statement of fact that we have, in fact, bilked somebody out of $30 million not only impacts our ability to get other investors. I mean, it does impact our ability to get other investors, but what it does is it puts in the mind of those other investors that we may be facing a $30 million judgment down the road. So Be careful for them. And there's no indication.
So if the statement had been that they attempted to bilk people out of $10 million, would we be here today?
If the statement was that we had attempted, would we?
You attempted to bilk people out of $10 million, would we then be here?
I think we would be here because that's not what the California court said. What the California court said is it was their goal to raise $10 million. And you attempted to bilk $10 million suggests that we had requests and gave information to $10 million worth of investors.
Okay.
And that's just not the evidence.
What if the statement were that they attempted to bilk people out of money? Would we be here then?
I think we might be closer into the context of substantial truth, but I think focusing on just that one statement in isolation.
Well, and I want to give you a chance to get to the other statements, but if you would concede that a statement that somebody associated with your client attempted to bilk people out of money could be substantially true, I'm having a difficult time seeing a defamation action that survives summary judgment.
On that one statement.
I mean, right, and we'll get to the other statements. But what is the, if it is substantially true that your client's out there trying to bilk people out of money, what reputation is there to protect?
Well, I'm going to go back into the fact that IER and USAR are not the same, and IER is not owned by USAR.
I'm not suggesting that, I'm not conscious of that position or that you've waived it.
Right.
But in the interest of time, my question still stands. Is there a reputation to protect if it is substantially true that a business has tried to bilk people out of money?
I absolutely think there's a reputation to protect. If in this context there was a cease and desist refrain order, and by the way, it was deemed by consent. So here you have a company who has had his wrist slapped and is now turning over a new leaf to be able to, like, in perpetuity defame their reputation because of something that they did and agreed to fix in one state. I think that's
Totally lost me there. So if they come in and they say, we agree that we attempted to bilk people out of money, but we're going to turn over a new leaf, that's still not fair game for somebody to comment that they, in one point in time, attempted to bilk people out of money.
But the statement didn't say attempted to bilk, and it's a very critical distinction in terms of the sting of defamation. It is a critical distinction.
I want to make sure you have time to get to the other statements. I'm having difficulty with the idea that somebody who admits they attempted to bilk is substantially different from somebody who bilked for reputational purposes. But let's not tread over this ground over and over. Please cover the other statements.
Okay. So the court found evidence that USAR has never raised $30 million, and that the Maryland documents the court found describe IER, not USAR, and there was a total of $62,500, and there was a big distinction between even $10 million and $62,500. The other statements.
Individual investor, is there such a distinction? If somebody steals $62,000 from me, they might as well steal $10 million. Because that would be catastrophic in the lives of an ordinary investor, right?
Well, I actually would disagree with the characterization that the $62,000 was stolen, and I'm not sure that's what the Maryland order says either. I think what the Maryland order says is you raised $62,500 in a way that violated our state securities laws. And I know that sounds like a distinction without a difference, but in the world of investing, that's very different than stealing.
It is a meaningful distinction. I grant you that, but I guess the other thing this conversation illustrates is you have several people in the well of this courtroom trying to be very careful with their words and still occasionally misstepping. Does the First Amendment not allow a little breathing room for that?
Your Honor, the statements by Get Real were voluminous, especially the statements that he took from the Dallas decree that said there's no factual finding for these, and published every one of those 40 statements. In a defamation case, I'm going to have to go through every single one of those. And the standard right now is, can we survive summary judgment motion on those? An example of a circumstance where somebody like John Doe would prevail in a case like this would be, there was one statement about somebody, and it was clearly an opinion. I said so-and-so was a dishonorable man, or I said so-and-so was worthless. And then I sue him for defamation for saying I'm worthless. And then he says, well, no, that's a statement of opinion. That's a circumstance where Doe would be able to maintain their protected identity. In this case, there are so many statements that weren't even addressed in the pleadings below. The judge says.
Well, let's stick to the ones that were addressed in our limited time.
Okay.
But I guess, are you suggesting then that we should read Mobalisa as holding that any time somebody mischaracterizes an official document relating to a public proceeding, they're going to lose a motion to quash?
If they mischaracterize it in a way that's defamatory, and they do so repeatedly, yes, I think that anonymous posters on the internet need to take care when they are mischaracterizing what happens in other places. You know, if I'm arrested for a misdemeanor and somebody goes online and says she was convicted of a misdemeanor, that's two very different things. And so I think it's important we look at the precision of the statements that were made and what evidence DOE has to support the truth or falsity of those, and whether or not we have raised a fact question to those.
Well, that's an illustrative hypothetical. So if you're convicted of a misdemeanor and or you're arrested for a misdemeanor, and an anonymous poster says you are convicted, let's assume that you haven't been acquitted, that you're simply
still in the system,
in the process. You would consider that sufficient to pierce the anonymity under the First Amendment?
I would, Your Honor.
All right. That does impose a fairly stringent burden on people to understand the exact meaning of legal terms and legal proceedings, which may be reasonable. But
certainly when it appears they may be making a career out of doing it. I mean, and that's one of the public policy concerns we have, is that if you don't hold people like Get Real to the truth of their statements, you run the risk, you invite misconduct. You invite people to nefariously say bad things about other companies because they're anonymous. I see that I'm out of time. Thank you.
Mr. Allen.
Thank you, Your Honor. Both the California and Washington orders say on page 1 that IER is a wholly owned subsidiary of U.S. American Resources, Inc. And everything that was in the initial statement of charges was incorporated by reference in Washington. The orders from California and Washington speak for themselves about the nature of the misrepresentations. And I'd like you to compare the summary of allegedly defamatory statements on page 3 of the court's ruling with the content of those orders, and it becomes very clear that what DOE said is within those four corners. California courts have already decided that illegally selling securities is not less defamatory than selling illegal securities. The case is Moss v. Kroner, 197 Cal App 4th 860, and it applies the same unregistered investment provision that the California court was construing. You look at those statements on page 3 of the ruling, they're all about bilking and defrauding in a boiler room.
Well, did they ever, how much money did they actually take in the California?
I don't know, Your Honor. It's not in the order anywhere. Only what they attempted to gain. I do need to...
Though that there are some fairly significant differences between the statements published and the content of the order.
I don't really believe that's true, Your Honor. I think they're subsumed, and I think page 3 of the ruling illustrates that. And I do need to point out that we did address mental state at page 2 of the reply supporting the motion to quash, because we said that DOE couldn't be malicious, reckless, or negligent in relying on adjudicated findings.
But my question was if you would put it in your petition to us.
I don't think it's not addressed in our petition to you, Your Honor. You're correct. Thank you.
Thank you. The matter is deemed submitted. A decision will render in due course.